Alrighty. Well, good afternoon, everyone. Thank you for joining us for our second seminar in our Patenting Your Technology workshop series. Today, we're going to kind of give a little bit of a high-level overview about what's actually required when you're trying to put together a application for protecting your technology. What are the things you need to have ready when you're trying to, well, hopefully secure a patent on your innovation and your idea? In the first workshop, we actually just kind of gave a brief overview about what are the differences between things like provisional patents, non-provisional patents. What do you need to know? What are those kind of first steps? What are those things that are really critical for you moving forward? And in this one, we're actually really going to focus on those first steps. So in today's session, we're going to take a little bit of a different track to it, because in our first one, the engagement with our speaker really was a central focus. There were a lot of really great questions. Hearing information from someone that's actually been in the trenches is a lot more useful to y'all than just to have me wax poetic about it. So what we're going to do is I'm going to run through some really kind of generalized information about what are the things that you need to do, what are the things you need to know about your actual application for protecting your technology, that intellectual property that's so key for people. And I'm going to take about 10, 15 minutes to do that. And then I'm going to actually turn it over to Eric Blatt. Eric is a former USPTO examiner. He is also a patent attorney now. So he has some really great knowledge, some great behind the scenes, and is really going to speak towards that. What is so important about this process that people just constantly either forget about, don't know about, or unfortunately sometimes miss the ball completely. So beyond the kind of basic information about provisional and non-provisional, really when we're talking patents, there's three types of patents that people often refer to: a utility patent, a design patent, and a plant patent. So when you hear utility patent, if you ever hear someone say, well, I have a patent pending, or I got a patent on this, more than likely 95% of the time they're talking about a utility patent. A utility patent is, just as catch up or background information for people that maybe missed the first session. The utility patent is that novel idea that is useful and can be utilized for something. So if you find a new way to transform a material, if you have a really great new software platform that has an amazing algorithm built into it. When we think patents, you think Apple patents or Google or those big companies. Those are utility patents. The next one is a design patent. So a design patent is different than what most people will typically think of when they think design patents, because you think design, you think maybe engineering design, maybe structural design. A design patent, though, is just the thing that makes it pretty. And I kind of say that half jokingly, and only half jokingly, because really a design patent is just ornamental. It's what is it that you did to this that was different, makes it look different, but has no place in form, fit, or function. And then the other one is a plant patent. Yes, you can actually patent plants. You have to have either discovered it and reproduced it asexually or created it from asexual reproduction. But there's not a lot of plant patents that happen, because more than likely we found most of the plants that already exist or that we can actually reproduce. But the big thing to know is if you're going after a plant patent, you can definitely ask us some questions, but neither myself or Eric are super versed about patent patents. There's just not a lot of people that seek them.
I
But
know nothing about plant patents. All I know is that the Honeycrisp apple is patented.
see, and I didn't even know that. So plant patents, ask Eric. He at least has one data point for you. But kind of all kidding aside, if you create a new plant, if you create something, if you find something, as long as you can make essentially a copy of that, which is that asexual reproduction, so grafting, cutting, it has to be genetically identical to the previous one. It can't be offspring, it can't be offshoots. Then you can patent that. If you cannot do that, it is not patentable. And that taps out my knowledge on plants. And so how do you actually secure these patents? Well, each one of these is going to require some sort of application and some sort of documentation, some sort of kind of write up on why this is different, why it's novel, why it's unique, why it hasn't been seen out there, why it's useful. There's a lot of bases you have to cover. The first step in that, though, is really you need to kind of assess what is the potential for this? Is it commercially viable? Can I actually make a product and sell this? As we talked about in the first session, sometimes the patent process can be expensive and take a while. And if it's something that maybe you can create a product out of it that has a worldwide market of $2,500 a year, you're going to spend more than that $2,500 just to go after these protections. Does it really make sense to do this? So the first thing you need to look at is the just economics of the situation. Is it something you can actually make money off of? Is it something that's really worth protecting? Is it something that's, beyond that kind of scout level merit badge that is going to help your business? If not, then maybe it's not worth actually seeking these protections. But when you're going after one of these, if you make that business decision that it's worth it for me to actually pursue this, one of the things that you need to know is you're going to have to come up with some claims. And your claims are essentially the backbone of your patent. Your claims describe why this is unique. It describes the protections that you're trying to seek, the ways that you're keeping others from copying what you've created. And a thing that you need in those is some sort of drawing or figure so that the examiner can figure out, what is this? How does it work? How does it function? How is this actually unique? And if you're filing a design patent, there really is only one claim. That's the design. You need some sort of graphical representation in that. It needs to either be a full and detailed drawing, maybe a black and white photo. You can include color photographs, but you actually have to get a petition saying why color is necessary. So I would only do that if somehow the color is part of it and the variations in the color or maybe the gradients in the color are hard to point out in a figure. Otherwise, you want a figure or a black and white photo that is labeled over top of it. But for a design patent, really the application is the design itself, that you have some sort of description of it, but those figures that show that minute detail, show the variation and topography of the design and how it actually functions on whatever you're putting that design on, not how it functions, how it lays there. Remember, it can't be functional. That is the sum total of your application. That's all you have to do. That's all you have to submit. Because of that, design patents are typically a little bit, cheaper than other patents, which a utility patent, again, can be very expensive. But that's the basics of what goes into that application. I'm going to just run through a couple of things, particularly for utility application, that make putting together a strong application really worthwhile, or kind of those tips and tricks. And then Eric is going to dive into that because he has a lot more experience in that realm, in that world, than I do. So what's necessary? So again, utility application, anytime you hear somebody say, oh, I have 12 patents, or oh, I have a patent pending on this, almost always they're talking about utility patents. And when you're putting together that information for that application, the couple of key things that you are going to have. There's a lot of documentation that goes into this. So a specification document, that's really just a description of the innovation and how people would actually use this, how it would function. This kind of gets to the heart of that thing, that is, how is this useful? Because remember, this has to be useful. It has to be something that somebody else can use, somebody else can utilize. If it's not useful, it's probably not patentable. Cross-reference to related applications. So if you filed a provisional, you'll want to reference it here. This is also where you put in things like continuation in parts, divisional patents. If this is a derivative of it, but it's monumental change, this is where you're going to put that information and where you're going to reference that prior work. And you also need a background. So just how did this come up with, or how did you come up with this? What does this actually pertain to? Kind of what field is this in? And field, not as in, standing out in the field, but things like digital engineering, material science. What aspect of scientific discovery is this related to? You also need a description. Description is just, how can this be created or reproduced? How does this actually work? How does this function? What is the kind of science behind it? And then probably the biggest part of your utility application are actually going to be the claims. So the claims, again, set forth what's being protected and how it is unique and useful. Claims are independent, or claims have to be separated and numbered independently. Claims can be dependent on prior claims within that application, providing some better description or nuance, but they have to be kind of bracketed on their own, because when the examiner goes through these, they're just going to go down that list and go, okay, claim 1 says this. Is this something that they can actually protect? Claim 2 says this. Is this something that seems valid? Claim 3 says this. Oh, well, no, somebody else has already claimed this. We're going to have to strike this claim. They're not going to go through and just kind of throw out the entire application. What they're going to do is go through it on a claim by claim basis and examine each one of those claims by themselves. That's why you have to number them independently. But it's also why they need to kind of be broad. That way you can cover, derivatives of the invention. If you're creating a bicycle, you're going to want to cover things like two-wheeled modes of transportation, getting from point A to point B via, human power, the drivetrain system that is exploded out so that it can be put on anything with, 2 wheels, that kind of information. You're not going to put in there something that is a total offshoot like wings and how it moves through the air, because that's not what a bicycle does. If you got a bicycle that flies, though, hit me up. I'd like to invest in that. I'm sure that there would be some really great, use for that, and that it would make a heck of a lot of money. But that's really kind of the things that you cover in that utility application. That thing that just makes this so novel, so unique, so different. The claims are the biggest aspect of that. And putting together claims well is actually one of the biggest hurdles for people. It really impacts what you're going to do in the future, how you're going to take this to market, how you're going to continue to protect it, and what is that 20-year timeline? Remember, you can actually have a patent for up to 20 years. You got to pay maintenance fees on it. But your ability to protect that technology, protect the derivatives that can come from it, to give you that market edge and give you that lead, that gives you a leg up for your business is all very important to the claims, how they're structured, how they're written, and what they protect. And with that as kind of the showcase, I'm actually going to turn it over to Eric.
Okay, I'm unmuted now, so now I can talk. Thanks, Del. So I will give a little bit of background about myself, just so you know who I am and can appropriately weigh the credibility of the material that I share. I am an IP attorney at Rothwell Fig Ernst & Manbeck. That's an IP boutique specialty firm in Washington, D.C. I've been working here for about 5 years. I do a mix of patent prosecution. What that means is I help clients, most of my clients are small businesses, a lot of startups, a lot of them are SBI or awardees. I work with them to draft patent applications. I negotiate with patent examiners to try to get the patent examiners to allow the patent applications in a way that's time efficient and cost efficient for my clients. I also do a broader mix. So a lot of patent attorneys just do, patent prosecution in semiconductors or patent prosecution in telecom. My practice has been a little bit broader than that. In addition to doing patent drafting and prosecution, I've done litigation. I've done a lot of litigation work. So, in the early stage of the patent cycle, you're trying to get it through the patent office. And then as you go further on, 5-10 years later, you have a product on the market, someone copies you, and now there's a lawsuit. So all the things that entails, the briefs, the claim construction, the hiring the experts, all that stuff. And I do IP transactions. So if your company is successful and now someone's interested in acquiring your company, they will probably do some due diligence on your patents. They're going to look, make sure that you actually own the patents that you say you own. They might look at the claims and figure out whether they're effective and whether they defend your technology effectively. It's possible that they'll look at whether those claims are valid over the prior art or if there's any other defects in the claim. That's pretty burdensome. It doesn't always happen. But all those deals I help clients with. A little bit of background on, I'm a member of the IP committee for the Small Business Technology Council. So that is an advocacy and educational organization that's focused on the SBIR program. I spoke at the 2017 and 2019 national conferences on SBIR data rights and patents. And we're not talking about SBIR data rights today, but if you're interested in the SBIR program, that's something that you should know about as well. And so with that, I will go ahead and give the talk. All right, so Del did a great job giving background on what a patent application is, the parts it needs to have. There was a lot of focus on the claims. That was appropriate. The claims are by far and away the most important part of the patent application. I was a patent examiner for 6 years, and I will tell you, for maybe the first 6 months, I read the rest of the application. I would read I always looked through the drawings. That's something that I did all 6 of my years. But over time, I learned that it wasn't so important to look at the patent specification unless there was a problem in the claims. And then you'd go back and look at the specifications. But absolutely the most focus is on the claims. And that's why as a patent attorney, the first thing I do when I'm going to start writing a patent application is I draft the claims. Because if the claims are not correct, you don't know how to draft the rest of the patent application. The rest of the patent application is really just a way to support the claims and make sure you have what you need to get the claims through the patent office. So you file your patent application, and what happens next? So it goes into the USPTO. The USPTO has about 10,000 employees. There are about 8,000 of those employees are patent examiners. So first, the patent examiner the patent application will go to pre-examination processing. They'll make sure that you have the right parts of your patent application are there. They'll make sure that you have filled out your application data sheet correctly, that you've got your inventor declarations. You might get a bounce and say, hey, that you're missing this part, please submit it. And then assuming you can get through that, which almost all applications do, you'll get docketed to an examiner in an art unit. So examiners, like I said, there are about 8,000 patent examiners. They don't all work in one big office. They're spread out across 6 buildings, and each building has, 1,000 examiners or so, and each of those examiners are split up into little technology groups, work groups, about 10 to 20 examiners per. And you can imagine if there's 8,000 examiners and each work group is 10 to 20 examiners, those work groups are pretty narrow. And the examiners will review a lot of patent applications in that particular technical area. So over time, the examiners will actually learn pretty well what prior art is out there. Occasionally, you'll get docketed to the wrong examiner. It used to be that you could transfer to the right examiner, but now the examiners are telling me that if you get docketed to them, you're pretty much stuck with them, and they'll just do the search as best they can. Usually it sits there, so it'll get docketed to the examiner, and then it'll just kind of sit on the examiner's docket. So I was an examiner. I had a docket of a couple hundred patent applications waiting for me to pick up, and you kind of just go down the list, trying to do one a day, and you might, the arguments with the attorney take a little bit less time, but for a new application, it pretty much takes a day. And what I would do is I would pick the application up, I'd take a look at the claims, I'd try to understand what those claims meant by looking at the figures. If I had any questions, I'd then go into the specification. Then I'd have a pretty good idea of what the invention was and what the applicant felt that they had contributed that was new. And then I would do a prior art search. So I would fire up my search tools, and I'd plug in the right patent classifications to pull up all the earlier patents in that field. I would run keywords that are related to the invention, and I'd see how close I could find, earlier references, how close I could find to the invention. Most examiners spend between about 2 and 6 hours looking for prior art. And you might think that that's a pretty short time, but you can actually do a pretty decent job of looking at all the relevant stuff if you've done this enough times in that narrow technical area. In fact, if you're good and you've been there for a while, you might look at something and say, hey, this is very similar to something I examined last year. I'm just going to pull that search, and oh yeah, I know about these references. So these are, maybe what I'm going to start with, and I'll see if I can find anything better in the remaining 2 or 3 hours. So generally, the searches are fairly effective, particularly in the patent world. Examiners are a little bit less good at looking for scientific journals and the like. But the examiner will probably find something that's reasonably close, or they might make a mistake, right? So they might misunderstand your invention completely and just find something that they thought was close. And then they'll generate a report on what they found. It's called an office action. And the examiner's job when they issue an office action is if they can find prior art or any other defects in the claim, they are supposed to reject your claim. That's kind of the goal of doing a prior art search, right? So I search for 6 hours, I see if I can find anything close, and my goal is to find something close as a patent examiner. And then they'll basically copy paste your claim into this office action. It's a Word document. And then they will say, your claim has elements A, B, C, D, E, F, G. They'll break it out and they'll say, element A is in this prior reference 1. And element B is also in prior reference 1, and they'll go down the list and they'll just say, this is disclosed, this is disclosed, this is disclosed. Hopefully there will be things that were not disclosed in the prior art, in which case either the examiner will say, you know what, there's no art, there's no prior art references that teach this feature, therefore it's allowable over the prior art. That's what you're hoping for. But more often, at least in the first instance, the examiner will say, this prior art reference teaches elements A through D. It doesn't teach element E. However, element E would have been obvious in view of this other reference, which does teach element E, and it would have been obvious to combine the references to get the claim as a whole. That's probably what you're going to see in the first office action, and then you go from there, you argue. There's also a possibility the examiner will find minor defects in your claim. There's rules, so I don't know how many of you are computer programmers, but when you're writing code, if you have a typo or if you use the wrong operator or the wrong word, it doesn't work. The examiners are supposed to look through your claim to see if there are any syntax defects. So example, if you say the when you're supposed to say A, that gets kicked. Or if you call one of the elements in your claim by one name and then later use a slightly different name for that element, it's going to get kicked. Finally, if you're doing anything that's a medical diagnostic, financial technology, or certain types of software, so in the software world, if it's very technical, you're probably okay. But if it's more business method-y, you might get booted on section 101, which is subject matter eligibility. The law in terms of subject matter eligibility is very murky. I don't think it's probably something we have time to go into today, but if anyone has questions on that, I'm happy to answer them. Okay, so when you file your patent application, like I said, it goes to the examiner does a search. About 80% of the time, that first office action is a rejection. So the examiner finds prior art or other syntax problems in your claim and finds some basis to reject it. So why does that happen? Why are people filing patent applications that are going to be rejected by the patent office? The answer is a lot of the patent applications that are initially rejected are actually patentable. It's just a matter of the examiner's job is to find a basis to reject the claim, at least in the first instance. So you can imagine if I'm your examiner and I'm spending my 6 hours looking for prior art and I can't find anything, and so I allow the claim, that might say your invention is very, very inventive, or it might say maybe I didn't look very hard in my 6 hours, or maybe I wasn't actually looking at all, right? So the examiner kind of wants to find something to show further effort, at least in the first instance, with the expectation that if they're wrong and the rejection isn't very good or the prior art they found isn't very close, you'll come back and tell them, right? It's the beginning of a negotiation. And so most of the time you do get a rejection the first time, and that should just be, you should take that as an opening position that you're going to start a negotiation. A lot of applicants are very disappointed with the first rejection, but it's very, very normal, and it's kind of the expected outcome in the first instance. The other reason that it happens is applicants, when you file your patent application, maybe you do a patent search and you have a decent idea. Most people actually don't do a patent search before they file a patent application. And even if they do a patent search, it's not exhaustive, right? So I think there's 11 million patents out there, US patents right now. You're not going to look at 11 million documents. You can't look at 11 million documents. You're going to narrow that with your keywords, and you're going to try your best to find whatever it is, but you might miss something. So generally, you're going to come in, because you don't know what all is out there, you're going to come in with the broadest possible claims that you think you might be entitled to, and you're going to see what the examiner finds, right? So you start out with broad claims, maybe the examiner finds something on broad claims, and you narrow as you go. So examiners know this, and they find whatever they can, and if they find a basis to reject, again, you make an opening offer, they make an opening offer, you go from there. And that's it for this slide. So how do you improve your outcome? How do you get through this? How do you navigate this process in a way that will get the patent through in a way that is cost effective, that will get it through in a way that the patent is issued when it's still useful to you, and without narrowing your claims so much that the claims wind up not covering what you're doing or what your competitors might do, right? So you have your implementation for how your technology could be done, but in a world where your technology is very successful, your competitors, they might be the big tech companies, or I don't know exactly what everyone's doing, but they will look at your technology. They might even look at your patent, because if you're following the marking requirements, you'll put the patent number on your product, and so they'll look at your patent and they'll see if they can find a way to achieve the benefits of your technology, essentially copy you, but do so in a slightly different way so that they don't fall within the scope of your patent claims and therefore don't infringe. So you want to make sure that your claims are broad enough that they're useful to you. And anytime you're negotiating with the examiner, you need to be thinking about, okay, am I going to amend my claims? Am I going to narrow my claims? And how am I going to narrow my claims in such a way that the patent still covers what my competitors are likely to do? So when you are going through the process of negotiating with the patent examiner, your primary lever is what the claims say. So again, This is by far the most important part of the application. You need to think very carefully about how you structure your claims. Every single word you use in that claim is important. If you're in a lawsuit and there's one word that is defective, right? If there's one word that doesn't quite cover what you're trying to capture, or doesn't quite cover what your competitor is going to figure out to do 5 years from now, then they don't infringe and your patent winds up being useless to you. So you need to think about every single word. I put together an article. If we're going to circulate this PowerPoint, you can look at the link here. I put together an article, this tips for reviewing or drafting patent claims, has some thoughts about how to structure your claim, how to think about, select the words that you're using. But generally, the big picture is you want to find a way to describe your invention in words that will cover what you're doing, what your competitors will likely do in the future, and in a way that does not read on any prior art references. So anything that was public knowledge before your patent application was filed, you have to avoid everything that came before you, and that the examiner will agree is non-obvious over everything that came before you. You also want, if you can do that, you'll persuade the examiner, you'll persuade the court, and if your claim is broad enough, the idea will be infringed by your competitors. I'm happy to try to talk through specifics on there if anyone has questions, but it's exceedingly difficult to write a good claim. You have to think very carefully about it. Our firm hires attorneys that have engineering degrees and have 3 years of law school, and they come to the firm, and it still takes 6 to 12 months to get people writing claims that are really effective. It's a learned skill.
Really quick question for you, Eric, because I'm sure that other people might have it. One, just for people's reference, yes, we will be sending out these slides and the link to the recording. We're going to put it up on YouTube. But speaking of those claims, and you said that you also need to cover what your competitors might do. Do you recommend that people think on a certain timeline for that? Do they need to be trying to think 20 years in the future for the full lifetime of that patent, or do they need to think more short term?
I don't try to think 20 years in the road, just because I have no idea what the world's going to be like in 20 years. But the ideal situation that you want to be in is within my little niche of the world. I feel like I'm the furthest ahead, and I have a prediction for how the market is going to evolve and what types of products the big companies are going to want to launch in 2, 3, 4, 5 years from now. And I do intentionally try to draft my claims so that they will cover what people will be doing in 3 to 5 years.
Okay, great.
So I can give one example that might help frame people's thinking. So not a client's example. This is a very simplified example. But imagine that you invented the spinning plate in the microwave, right? So what I would think about is I would try to write claims, and so they capture sort of the essential benefits of my technology, my spinning plate in the microwave, but does so using words that are broad enough to capture other ways that people might want to capture the same benefit. So in the spinning plate example, the advantage of my technology is, well, the problem that my technology seeks to fix is if I put food in the microwave, it's heated unevenly, right? The beams are interacting in a way that I get hot spots and cool spots. That's not so good. So instead, I'm going to put the spinning plate in there. It's going to spin. Now the hot spots and cold spots, it all evens out because the food is moving within the microwave. All right, so that's the solution. The core essential aspect of that solution is not the spinning plate. That's one way to achieve that benefit, but you can imagine that there would be other ways to do it, right? You could move the power source up and down, or you could put a platform in there that moves up and down, or maybe it shakes. It doesn't, or maybe it just goes back and forth, right? There's a million ways to get that moving, the food relative to the energy source. The spinning plate is probably the best one, and that's why that's what's in my microwave. That's what's taken over. It become very successful. But you would want, when you're drafting the claim on this, you wouldn't want to claim microwave with spinning plate. You would want to claim microwave with support for food, that where the support moves relative to the energy source. And then you might have, so that would be your independent claim. And then you might have dependent claims. Dependent claims need to be narrower than your independent claim. And dependent claims are most useful as essentially a fallback position in examination. So if I come in with my broad claim that says support moving relative to energy source, and the examiner finds, I don't know, the platform that moves up and down, I say, okay, well, darn, I couldn't get the really broad claim, but I'll fall back on my spinning plate. So I'll start off with my independent claim. That'll be my initial offer that says moving relative to energy source. And in a dependent claim, I'll say where in the support is the spinning plate. And then I'll just fall back on that if I need to during examination. Or if the examiner misses the prior reference and I just get it through with the broad claim that I wanted, and now I sue someone for patent infringement, but they find the platform that moves up and down, well, I still have the dependent claim that I can fall back on in litigation and still win the lawsuit. All right, so if the examiner finds prior art that the examiner believes is close to your invention, and if you receive that rejection, as most people will in the first instance, what do you need to do? Well, the first thing you can do is what you should do is you should first look at the references carefully. Again, what examiners do in these rejections is they copy paste the claim essentially, and then they give you cites for each element. So element A, they'll say is in reference 1 at paragraph 234, right? So you need to look at paragraph 234, and you also need to look at the rest of the reference and figure out whether paragraph 234 actually says what the examiner says it says, because a lot of times the examiners get it wrong. So your first argument is the examiner says, paragraph 234 says this, but actually it says something completely different. That's just wrong. The reference doesn't teach the claim elements. The other argument, that's by far your strongest argument, by the way. It's much better to say the reference doesn't teach the element. But if the reference kind of does teach the element, and kind of all the elements, or if there's all the elements in the references the examiner proposes to combine, what you could say is, hey, even though reference 1 teaches elements A, B, and C, and even though reference 2 teaches element D, so this is the case where the examiner is combining 2 references, you can say it would be obvious to combine reference 1 and reference 2 as the examiner proposes, because, and you would need to give some sort of reason why it wouldn't be obvious to combine those references. Examples are the references teach away from combining in this way. So you find a sentence somewhere in the patent specification, or the reference that says, don't do this. Maybe it wouldn't work. So the examiner has said combine a microwave with a ceiling fan, right, to get the spinning. And maybe no one would know how to do that. And the specific references that the examiner found, just you couldn't make them work. Those are some examples. There's a number of ways to argue that it wouldn't be obvious. But generally, the best way to get past things is to find some sort of reason that the reference doesn't say what the examiner says. Or if you can't do that, you can amend your claim to put in some limitation that isn't in any of the references. All right, so once you're at the point where you've decided how you're going to argue, or you've decided if you're going to amend your claim and how you're going to amend the claim, how do you present that in a way that is effective and is more likely to persuade the examiner? So this is a big part of the skill of lawyering, or persuasion, arguing effectively. On that point, it's helpful to keep in mind that even though the examiner has at this point rejected your claim, and you may be feeling that they don't understand your technology and they don't know what they're doing and they're just out to get you, the reality is that examiners benefit from allowing patent applications. So I was a patent examiner. Patent examiners work on a production, an incentive system, right? They need to do a certain amount of patent applications per unit time in order to remain in good standing at the USPTO and continue to earn their salary. It turns out that the most efficient way to hit your production metrics is to allow patent applications and allow them to issue into patents. So if you can, and examiners vary, some are very stingy and some are very eager to allow. But if you can give your examiner a good reason to allow the patent, there's a good chance that they'll be willing to do that. Generally, it's more effective, at least in my experience, it's more effective to be amicable and think of yourself as on the same team as the patent examiner. You're just both trying to get to an agreement where both parties can say yes, than it is to try to bludgeon them down. And you can bludgeon them down sometimes. You can make arguments, you can threaten to appeal. If you get an examiner who's just stubborn, you might have to go for the bludgeoning tactic. But I always start by trying to be amicable, make friends with the examiner, try to understand what the examiner's views are, and be responsive to those views. The way that you do this and you figure out what your examiner wants to see in the claim is you schedule a phone call, right? I typically do this as an attorney. I typically prefer to do it just myself, but sometimes the inventors also want to be on the call. The way that I like to frame the conversation with an examiner is and this is coming from my experience at the USPTO as a patent examiner, I never liked when applicants got on the phone and said, the rejection is wrong, this technical point is wrong, or it wouldn't be obvious, and they jump right into the get-go, into the claims and the nitty-gritty of the office action, because as a patent examiner, that would put me on the defensive, right? So if you say, I'm wrong, then I need to say, well, no, I'm not wrong, you're wrong, and here's why. So that typically, and as an attorney, I don't think it's effective to just go straight into examiner's wrong. I think it's more effective by starting with the technology, explaining what the technology is, why the technology is important and valuable, and how it is inventive, how it's different than everything that's come before. And then frame that, so you'll pick the feature that you want to argue is inventive and not obvious over the prior art. You'll talk about why that's important and what it is, and then you'll contrast that to the reference the examiner found. So you say, my spinning plate is really wonderful because it moves this, and motion is really important because you need to heat the food evenly. And this other reference, if you look at it, it doesn't achieve motion, right? It's only a regular microwave. And so what I like to do is first get the examiner to agree that this is only a regular microwave and it doesn't have any motion at all. And before I even get to the claims or the specifics of the office action, let's just make sure we can agree on what my technology is and what's taught in the reference. If you can agree on that point, you can always find the claim language to make it so that the examiner will agree that your claims are distinguishing. But if you can't agree on what the reference says, then there's really no hope to find claim language. So agree on the technology first. Then I like to ask the examiner, we tried to claim this in a way that we thought was effective and would get around the prior art. I can see that you've disagreed here. What claim language do you think would help? A lot of times patent examiners won't want to answer that question because they don't want to put their position on the line. But you can ask the question, and if the examiner likes you, they might have some suggestions. And then you can say, okay, but maybe you don't have specific language in mind, but would this work, right? So you come prepared to your interview with what your technology is, why it's different. Then you offer the examiner an opportunity to say, whatever they think might be effective. And then you have in your mind what you're going to suggest. Then you suggest it, and a lot of times they'll say, okay, yeah, that would work. And then you get an agreement that if you amend the claims in this way, that'll overcome the art of record. And you do want to try to get them to agree that the amendment will overcome the rejection, because that makes it much less likely that they'll come back the next round and say, you amended the claims, I thought it would be good, but I was wrong. So it's good to just kind of cement that agreement once you get there. You can't always do that. Sometimes an examiner will take a position on the reference that you just don't anticipate, or that is just wrong, and then you need to probably switch to the bludgeoning tactic, and that can work too. when you get to the point where you're actually going to write up your response, you want to have a good position. You want your claims to be distinguishing over the references. You don't want to submit 5 or 10 pages explaining what your technology is and why the reference doesn't teach it. The problem with having 5 or 10 pages of argument is it becomes a minefield in infringement litigation. So, maybe you get the examiner to agree with your 10-page argument and you get the patent through. Now it's 5 years later and some other company is copying you and you want to sue them for patent infringement. Well, they're not going to give up, right? If they've decided to copy you, they're not just going to roll over as soon as you sue them. They're going to hire patent lawyers, and the patent lawyers are going to study your patent. They'll go back through all of the statements you made during the prosecution phase and all the statements that you used to persuade the examiner, and they'll find things that you said that were not right, or things that were not careful, or things that they can mischaracterize to make the patent mean something that you didn't mean it to mean. And now you have an infringement dispute over a claim term, a claim that they're arguing this term means this because you said this thing to the examiner. I just litigated a case where the case, it was a case dispositive issue. If we didn't win on this, we would have lost the case. And that the issue was, what does the phrase tip end mean, right? So you might think that this is silly and one little word doesn't matter so much, but the case would have risen or fallen on what tip end means within the context of the patent specification and everything that was said to the examiner during prosecution. One last tip, if you get to the point where you've persuaded your patent examiner to allow the patent, congratulations, you might think that you're done and you can stop spending your time and money on this. Generally, you're actually better off continuing to invest, unfortunately. So you get to the point where your patent is allowed. I would encourage you to consider before the patent issues, because you can't do it once the patent issues. There has to be what's called co-pendency. You have to file it before the first patent issues. You file another application with the exact same drawings and specification, but with different claims. And that's called a continuation application. You get the benefit of your original filing date. So now you're 3 years down the road. So let's say you file the first one in 2021. You get the patent allowed in 2023, let's say. You file your continuation in 2023. The prior art date, so the date you have to beat for prior art, is still going to be that 2021 date. It gets the date of the parent. And you get another set of claims off of the same patent specification. That is very advantageous because it means you don't have only one patent on the technology, you have 2 or 3 or 4 or 5 on the technology. And if you made a mistake in the claims in one of them, or if someone was smart in a way that you didn't expect and they've designed around your patent, well, now you have 4 or 5 other patent claims that you can assert against them. And so you've got varying claim scope, you've got multiple patents you can assert, and if your patent application is still pending when someone comes onto the market, you can actually do something even more powerful than just having a number of patents. You can draft claims specifically on their product, so you can be very deliberate with your claim drafting, and so it's essentially a litigation strategy, and that can make your claims, because now you actually have their product sitting in front of you, and you can be very deliberate and very strategic about what claims you're going to use in order to claim their product. It's a very powerful tool, and if you can afford to keep continuations pending, it's a very powerful thing to do, and I encourage you to do it.
So it might seem super reductive, Eric, but would you say one of the strongest tips you have for people is, since everyone is almost certainly going to have to deal with a patent examiner at some point during their application, to remember that a patent examiner is human, treat them as you would want to be treated, kind of remember that golden rule?
I think that is a great takeaway message. These are people who are just doing their job, and most of them would like to allow your patent application. You just have to give them a good reason to do so. Oh, I have more here. Okay, resources. Drafting good patent claims and drafting a good patent is very difficult. If you want to do it yourself, it's a difficult thing to do, but it can be done, and it can be done well. If you want to have assistance with that. A lot of firms offer reduced rates or specialized services for startups and small businesses. I do, one of the things I like to do is I will just pick up the claim drafting. So we'll have a call, the client will explain the technology to me. I will draft a claim, we'll go back and forth, and then I'll essentially provide guidance and outline for the rest of the patent application, and the client drafts that because it's very, very easy to mess up the claims. It's a little more difficult to mess up the rest of the patent application. So that's a way that we're able to keep the costs much lower. We can get it down to, I think, like 20 or 30% of what a normal patent application would cost. I think that the Arrowhead Center and the New Mexico State University has resources that may go live in the next couple months. If you're looking for money to pay a patent lawyer, there's the FAST program, which Dell has some information about, the resources that are available there. If you're submitting an SBIR proposal and you get funding, sometimes you can get TABA, which is money used for commercialization resources. Those can be used for patent development. USPTO has resources. They have a pro se assistance program and a patent pro bono program. And if you have questions and you'd like to talk to me, I'm always happy to talk to folks. I do a lot of consultations for free, and I'm happy to take a look and see if I can help.
Yeah, so for everyone's just kind of benefit of information, NMFAST, if you are in New Mexico and looking at putting together an SBIR or STTR application, and you think that having some protections on your technology might actually be useful, might help you put that proposal package together. There is the possibility that there can be a small amount of funding available for that. There are restrictions and there are requirements. So if you are in that realm, definitely reach out to me. But aside from that, Arrowhead Center recently was awarded a Department of, well, we're still in negotiations on a Department of Energy award called NM-SURGE, CERG, New Mexico Clean Energy Resilience and Growth Cluster. And one of the things that we are creating under there is actually an online curriculum to kind of guide people through this process, give them some documentation, some resources, kind of some navigable roadmaps or thought maps almost on, is this going to be worth it for me? What is my next step? What are the things I need to be aware of? Videos, resources. We are going to start that up during the first year of the award. So sometime next year, we'll actually start putting out information about that. People will be able to access some of those modules, some of those resources, some of those tools. If you want to know more about that, definitely hit me up in an email. I would be more than happy to talk to you about that, tell you what is coming on and get you on the mailing list for each one of those efforts as they come up. I just can't share much information about it because it's still in the planning process since we're still in negotiation on the award, but it will be, we would like it to be that one-stop shop of at least knowledge and information, maybe not just, hey, we'll sit down and help you write your application, because I ain't gonna be me. I can't help you write an application, but we can at least give you knowledge, background, and support on where do you go next. And along those lines, so now it's time for questions. We are going to have the last in our quote unquote last in our series of workshops on August 23rd. I'll make sure that everybody gets a notification about that and where they can sign up on Eventbrite. And then it's not really part of the series, but in September, we are going to do a collaborative session with Sandia, Los Alamos, and a couple of the research institutions around New Mexico. So you can learn more about what they might have in their portfolio, what they might have available, and how you can work with them and license something that you might be able to spin out for your own idea, for your own patent, for your own usage. So kind of keep that on your radar. But otherwise, Eric and I are here to kind of take questions, answer any questions you might have, and hopefully give you some great, just if nothing else, tips and tricks on what do you need to do to move forward. And don't everybody, fire off your mics at once, but go ahead, and if you have a question, unmute and ask, or drop it in the chat. So Stanfita, for the NM Fast, so the way that NM Fast helps for patent applications is we do have a little bit of funding called micro grants. Again, there are restrictions, there are requirements for it, but the micro grant can help pay or offset the cost for you to work with somebody like Eric on putting together your patent application, on getting documentation, on structuring claims. It's not a lot of funding. It is a limited award, so sometimes it probably won't pay for the entire work with the patent attorney like Eric and his firm, but it can help you get that process started. So that's how we provide help under NM Fast. Other questions? So a question came in, and this is actually a really great question, Eric. Do the negotiations with examiners cost extra? So the negotiations themselves don't, but the filings and response might, correct?
So it depends what you're talking about. If you are hiring a lawyer to do it, you may have to pay the attorney's time. That is a big part of what patent attorneys do, is they analyze office actions and look at the references and come up with ways to respond. Then there's the question of, if I'm doing this myself, does the USPTO charge? And the answer to that question is sometimes. So you get 2 bites at the apple for every examination fee. So if you submit, when you file your patent application, you will pay a fee that the USPTO calls an examination fee. And I think for small businesses, it's somewhere in the range of $500. And so for that $500, you get the examiner's time for 2 searches and 2 office actions. And so you get your first one, you argue, hopefully you're effective in getting the patent through in the next one. If not, the examiner does another rejection, and now your 2 is up. And so the second one will be called a final rejection. It's not actually final. But you've now finished your 2 bites at the apple. And if you want 2 more, you pay another $500 or so.
Kind of a great follow-up question on that, Eric, is, you said that the final rejection isn't actually a final. It's the kind of final off of the 2 that you paid for. How many times can someone go to the well and, off of that same application and continue to file examination fees?
As many as they would like, but you just have to keep paying every 2 times. Okay. And so I've seen cases where people filed each time you pay for another 2 bites at the apple. It's called a request for continued examination, or RCE. And I have seen applications where there have been 12 or 13 RCEs filed, and finally it gets through. That's a bad case. It's an expensive thing to do, particularly for paying a patent attorney for every single response. I have much better results than that typically, but it can happen.
Then another question came in. When doing the search, do you do global searching?
So as a patent examiner, or I'll answer as both. So the patent examiners are supposed to look at everything worldwide. But the reality is that most patent examiners are US based English speakers. So if you ask, most of what they actually look at in practice is going to be US patent applications. But they should look at things in Japanese and Chinese and Korean. It's just harder. It's harder because of the language barrier and because patent examiners are used to the format of a US patent publication, and the patent publications in Japan and China and Korea and everywhere else look a little bit different, so they're a little bit less efficient to look at. The other thing that patent examiners are supposed to look at is not just patent literature, but also scientific publications. They might Google, anything that's public, they're theoretically supposed to look at. But if you say, look at everything in the world and here's 2 to 6 hours to do it, that's not going to happen. So what do they look at in practice? It's mostly US patents. If you hire a patent attorney or a law firm to do a search before you file a patent application, it's kind of the same story. The only difference is, well, it's the same story. It's the same story. Depending on who's doing the search, you might have people who in other countries who are doing it. So they might look at different things, but they're using similar tools and they have similar time constraints.
So a follow-up on that, if an examiner finds something that was maybe filed in Spain, but wasn't filed for protections in the US, will they reject a claim based on a foreign patent that is not a US patent?
Yes. So the rule is you need to be the first in the world to come up with your invention. And if someone in another country came up with it first, it's not an invention to you, it's an invention to them. So you'll have to come up with a way to narrow your claim and so that it doesn't cover what the people in Spain came up with.
All right. Any other questions here? The question came in about FAST. Will we be doing a workshop on SBIR and STTR? Yes, we will actually have 2 workshops, 101 workshops coming up in August and September. Those are still in the planning stages. I don't have the actual dates, but I should have those dates soon. So when I send out the information on this, I'll send out that information about those 2 upcoming workshops. But yes, under FAST or NM FAST, that's what we do is we help people go after SBIR and STTR, help them go after those opportunities. So we do everything related to SBIR and STTR except create content. You don't want me writing your proposal package because 1, I don't know the idea. That's your job, man. It's your business, it's your innovation. But then the other part is we just don't have the background, we don't have that expertise. But everything else, review, critique, overview, kind of thoughts, we will definitely help people with. We just do not create content.
On the SBIR front, the IP point that I can be useful in this seminar is make sure that you mark your deliverables with the appropriate SBIR data rights legend. If you don't mark your deliverables to the government with the SBIR data rights legend, the government is allowed to publish it on the internet and give it to your competitors. But all you have to do is put the right legend on the document and that won't happen.
Kind of along those same lines, Eric, I know, earlier when you started off, you talked about, SBIR data rights and said, we're not going to get into it in this session, but it's constantly a question that people have. If you could provide, you already provided one kind of really great tip, but just that high level overview, what do you think is the most important part of SBIR data rights for a company?
Marking what I just said. The companies that I talk to, I would say I've talked to a lot of companies, and a lot of times they say SBIR data rights, I didn't know these exist. I didn't know I had to mark. Sometimes they say, I thought if I just put a copyright notice on it and that was good enough. No, the answer is you have to, I've seen people lose contracts because they put a copyright notice instead of the right legend. Other people, yeah, it's just very incredibly common that people don't know to do this. And that's pretty much, 95% of the ballgame for everyone who is working with an agency other than the Department of Defense. So if you're working with the Department of Energy, National Science Foundation, NIH, EPA, anyone, if you mark your deliverables, you're pretty much going to be okay. If you're working with the Department of Defense, it's a little bit more nuanced because particularly if you want to pursue patents, the reason it's more nuanced is the Department of Defense actually does contracts, right? So if you're working with DOE, they give you a grant to do your research on how to, do hydrogen or whatever else you're doing. Or if you're working with NIH, they want to help you get your cancer medicine to the world. And you just take the money and you do the work and you file your patents and that's it. If you're working with DoD, you might actually develop the thing and DoD might want to buy millions and millions of dollars of it. So you need to be a little bit more careful about how you're structuring your data rights plan. And you also want to think about, okay, if I file a patent application on this technology and I also deliver it to the government, when my patent application publishes, because patent applications generally do publish, or you can file a non-publication request, by the way. If you're working with DoD on a SBIR, and you also want to file a patent, you very likely should file it with a non-publication request. That's free. You just check a box on your application. It doesn't get published until it issues. So if
I'd
you're
like to point something out really quickly. You just said that the non-publication was actually free. I'd like to highlight that to people because pretty much everything that you do with a patent application, you're going to pay a fee on in some way, shape, or form. So Eric just told you that's free. It should be something for people to think about if that's a route that they want to take.
Now you're making me check and make sure it actually is free. It's either free or it's like $100. I think it's free though.
So I was going to say, if anybody wants to kind of make themselves go crazy and follow every single rabbit hole in the world, go look at the USPTO fee schedule. There's a charge for everything.
I'm looking at it right now. I won't look at it. All right, I think it's free. I usually when we file a patent application for X $1,000, the little fees, knowing precisely what they are, tend to matter a little bit less.
Yeah.
Okay, so you should, if you're working with DoD and you want to file a patent application, you very likely should file a non-publication request. And you may also want to think about, is it in my interest to file a patent application on this technology? Because if you developed it with government funds, so if you used your SBIR dollars to come up with the idea, or if you used your SBIR dollars to reduce the idea to practice, so build a working prototype for the first time, the government gets a royalty-free license to the patented technology. And the result can be you wind up waiving your SBIR data rights, but you have a patent that is not enforceable against the government. And so you've actually created an opening for the Department of Defense to give your technology to a large prime contractor when they wouldn't otherwise have been able to. So that's sort of an enforcement trap that's out there if you're working with the Department of Defense, and you need to think about that a little bit more carefully. But with the grant agencies, the NSFs, the DOEs, et cetera, they don't tend to buy your technology. They're just hoping you develop it and sell it to the commercial world. And so you don't really need to worry about that as much. Just mark your deliverables and you'll be just fine.
All right, great. Well, everybody, want to thank y'all again for, attending today, listening to Eric and I discuss a little bit of the ins and outs of creating a strong application and really just what is that best path forward? What are those tips, tricks, and nuances that everyone wants to be aware of. Also want to thank Eric greatly for sitting in and giving such a great presentation and a kind of overview and walkthrough. It's a lot more in-depth information than I would have been able to provide because I haven't lived that world and that life that he has. So he is a fount of knowledge. He gave his email and contact information. I'll make sure that that's also included in the wrap-up email that will go out, that will have the slides attached to it, as well as the recording whenever I get it edited, transcribed, and posted. But if y'all have questions on, moving forward, what is the best path for me? What are some of the tools and resources I can utilize? Or even, hey, I want to find out more about SBIR and how I utilize these programs for my innovation, how I can make some best practices out of that. Do not hesitate to reach out to me. Everybody got an email from me this morning as a kind of reminder and link about how to access today's, but you'll also get the email from me hopefully tonight, more than likely tomorrow. I don't feel like being up till 9 p.m. waiting for a video to encode. But y'all will get that information as well as Eric's contact information, and just let us know how we might be able to help y'all move forward.